I just want to talk to you about arbitration. And I know that Judge O'Neill at the beginning of this conference spoke about the pressures that we are all under, practitioners and of course the judiciary. And I shamelessly raise this because earlier this year I qualified as an arbitrator in children, in the children's scheme, and been working behind the scenes to try and understand what the appetite is, if there is one, for looking at alternative disputes, dispute resolution models, certainly within the Northwest. Before qualifying as an arbitrator, I had engaged in a number of neutral evaluations, which I would say worked very well. So it's what you would expect. Parents that have separated, albeit on good terms, that conscious uncoupling, as we see Gwyneth and Chris doing so well. They get on the phone and they say, you know, we want to do this with peace and with respect, but we just need a bit of help. And so they come in, the ones I've done, we've done on a Saturday, so they're not distracted with their professional or work commitments. Children are sent off to grandparents or friends or family, and we spend the day talking it through. And then in effect, I give them my view, my indication as to what I think a judge would do if they took this to court. And whilst I've only done 3 of them, they all signed up to the indication. They were then signposted to solicitors who drafted that into an agreement that was signed, sealed, and job done. And the feedback from those couples was that it was a process that worked for them. So clearly it is very fact specific. But it meant that they could move on in their respective lives much quicker, with less stress, with less fallout, and hopefully saving money in the process. Of course, arbitration is a different model because that is something that binds the parties that agree to engage in arbitration. So for those of you that don't understand what arbitration is about, I'm just going to explain it. For those of you that do, just bear with me. So it's a form of dispute resolution that takes place outside of the courtroom. The parties enter into agreement under which they appoint an arbitrator to adjudicate upon the dispute. And fundamentally, they agree to be bound by the reasoned written decision of the arbitrator. In terms of children work, it covers generally any issue between parents or others holding parental responsibility, or someone else that has a sufficient interest in that child's present or future welfare. So, for example, a grandparent. The issues that can be brought into arbitration, looking at living arrangements, you know, who are the children going to live with, who they're going to spend time with, looking at holiday arrangements, the logistics. We can also assist with relocation in this country or relocation to Hague Convention countries, issues around education, issues around routine and non-life-threatening medical treatments. Of course, there are some issues that are not suitable for arbitration and are barred from that: child abduction, relocation to non-Hague Convention countries, anything life-changing or threatening in terms of medical treatment, if one party has any mental capacity issues, or if a party is a child litigant. But the benefits that come from engaging in arbitration can be speed in terms of resolution of the issues, the cost, obviously saving both sides money, the flexibility and the choice of arbitrator. And similarly to what Ruth was saying about relocation, parties can bring one issue into arbitration, but if there's several other issues, they can leave those outside of arbitration and develop a sort of building block approach. And that building block approach may be preferable and or may bring additional benefits whilst they're in the system waiting to get before a judge.